All right. Good morning. Finally. Welcome to cold morning here in Salt Lake. We didn't get any snow at my house over the weekend, but it's creeping lower down the mountain. Um, which meant our Halloween party had to be inside instead of outside like the last 2 years. And that storm had me in a lot of pain last night, hence me being later than I wanted. Um, so Today should be the last day of evidence in the Darrell Brooks trial. If he testifies, it's today. And really, I have no idea, even though we're behind, I don't know if he will or not. My guess is he will. As I was getting ready this morning, I was watching Dr. Grande featured Darrell Brooks. And as we know, he has officially been diagnosed as having a personality disorder. We don't know specifically which one. Dr. Grande, while not being able to diagnose him, said he sees traits of narcissism, paranoia, and antisocial personality. He is very Looney Tunes. So after we get finished here today, you should go watch Dr. Grande's feature on him. It was pretty good. Um, so with that, let's get started. And good morning, Static. Looks like I rewound to a preparation stage. They probably haven't called the case yet, so find a good place to start. Unless you find, 10 minutes of Brooks shuffling papers to be overly exciting.
Morning, Judge.
Okay, that's about it. Let's play from here. Morning, Enigma.
Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Morning, Judge. Sue Upper, Leslie Basie, and Zach Woodshell appearing for the state of Wisconsin.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and
Morning.
value all of the charging.
Oh, he discovered Brady.
Available for the discharge of all obligations.
How fun.
Connected with this case. I do not dispute any of the facts.
Problem with that is he's already been provided all his Brady material, I'm sure. His failure to look through the discovery boxes doesn't mean Brady was violated.
Individual known to this court as Darrell Brooks is present in person in custody. However, he is wearing street clothes, a suit and tie, and a mask.
I was not expecting anything but crazy.
It is noted. All right, Mr. Brooks, just preliminarily.
He said Mommy would show up if he told her to show up. She didn't need no subpoena.
Record, I don't consent to being called that name.
Apparently, he didn't tell her.
Anticipate
Or
calling any witnesses today?
She needed a subpoena.
I don't believe today.
Today's the
We are
day.
here for the continuation of testimony.
He doesn't believe today.
The only witness that I'm aware of that's on your list that you added is your
I
mother,
mean, does he
Dawn
think he
Witz,
can
so I
get
would
him
expect that if she's
in
going to
after
testify, she would
closing?
be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
Oh, I haven't looked. Let me look.
I mean, there's an interlocutory
Actually,
appeal.
I addressed one to you and then one to
I-
the prosecution.
I have no idea. Probably sovereign
Is the audio
citizen mumbo jumbo.
The audio's on. Do you know when you sent those?
Saturday.
At this point, like I said, I haven't looked ahead.
State receive anything through
I
interoffice communication?
think
We have
he's
not. I just
testifying,
checked this morning to see if there's anything new.
having not looked
happening.
into the
That's
future. I still
been
think he
received from my
testifies.
office. And I should say.
He's a big enough narcissist.
Clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state,
No objection.
from you, sir.
No objection. I
Wow.
definitely want those documents received.
I thought he'd
important
object
information.
just to be difficult, even though it's his issue.
You said you forwarded them to a staff member on Saturday.
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
May have been.
And those are two ICF forms?
Morning
Yeah, one addressed
scamorama.
to you directly and one addressed to district attorney's office.
Boy, that's some noisy typing this morning. Of course, he has transitory deafness. It was a busy, cold weekend, Scamorama. No snow at my house yet, but it's creeping down the mountain.
I will send it with high importance and we'll see what response I get.
Snowbird
But I don't
But
have
around
anything.
2 feet
If you want to
of
generally tell
snow,
me
so
the topic, we can cover it verbally.
hopefully that's a good
The
sign
topic
for the
is,
coming ski season
pertaining to
and water year.
exculpatory evidence. Some things were learned.
Oh, some things were
and,
learned.
Once they came to my attention, I felt the need to immediately address the court.
Were they in your
about this
discovery? Is
information.
that where you learned it?
Right? What
The-
information? Make an offer of proof for me, sir.
The expert witness for the prosecution in regards to
Got close for us.
I believe it was inspecting the vehicle. Officer Ryan Schultz.
My computer
was
says
asked.
34.
Did he know if there were any recalls on that vehicle? And
That's not
I believe that-
exculpatory.
a Brady claim should be visited because there were in fact recalls on that
Good
vehicle.
morning, Jamie.
In fact, there were recalls
John?
on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where
That's not
Ford company
Brady
were
material.
sued because of this, and those vehicles models from the year 2008 through 2010 were recalled. And
And where did you find this
That
out?
is very important information in
That's
regards
not
to
Brady material for
the
starters.
vehicle in question being a Ford Escape 2010. This information is very easily obtained.
Well, then you should have
just by
obtained it.
pulling it up, and you will see a class action lawsuit.
It's your
Obviously,
job.
if it's a class action lawsuit, then it's pretty easy to.
Besides which,
So what's
this
your
is not
request, then?
Brady material. Brady
My
being
request is
exculpatory evidence.
to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles,
This guy is unbelievable.
and in light of the
Why didn't you know? Why
fact that
didn't
these
you look
vehicles
it up
were
to
recalled
cross-examine him?
because of this malfunctioning,
If it's
throttle
so
body.
easily findable, like you say, it's so easily
Or,
available, why didn't you find it?
I believe it's counts 1 through 73 to be dismissed.
I mean, 1 through
All right, what's the
73.
response from the state attorney?
Thank you, Your Honor.
I think that's why he's focused
as
on
Trooper
10.
Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape.
Just because there was a
As
recall
Trooper
at
Inspector
a
Schultz
time
noted during his
doesn't
testimony
mean there's an active recall.
that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old. It has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report.
Oh, hey.
There was no recall in the throttle body.
Almost like
NHTSA
recalls
did do an investigation into
are
allegedly defective
prophylactic.
Ford throttle
They
bodies,
find
which
one
would have
problem and
impacted
extend it
this
to
year.
all of the same model.
Basically, the electronic throttle body failures would have resulted in engine stall
Oh,
or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So
exactly.
if this
The throttle
hadn't been
body
activated
and
on this car,
brakes
which it was not, but if it
are
had been,
separate.
and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit.
Ooh.
Further, if there was this, he would have observed material buildup on the commutator. There was
They have
no
the
such buildup
DA that
observed.
knows nothing
There were
about
no
cars
problems
discussing this
with the
one.
throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the
And that problem would have been
legal
irrelevant
inspection.
anyway.
The defendant had the opportunity to cross-examine Inspector
Exactly.
Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway
Traffic Safety Administration.
Administration. There are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls.
Oh, hey, wow.
So it's a moot issue.
I don't believe it's a new issue. And I actually
Well, give us a reason why.
The report should be in the mailroom as we speak. I had everything sent over priority mail, the actual information about
Once
the class
again,
action lawsuit, the actual
this isn't
information
Brady
about
material.
the
You could have
recalls for
found
those
it.
models, like I said, 2008
I mean,
2010. Now, in all fairness, Your Honor.
morning, Steve.
That's why I was asking.
His
for
failure
a
to investigate
Brady claim
isn't a Brady
on this.
violation.
Um,
This isn't information
seeing as how
that's
when
uniquely available to the
vehicles are purchased
prosecutor.
from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens.
So take it to a mechanic.
And seeing it's a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning. And
But you've brought no evidence
I
that
believe
yours
with
was
that,
malfunctioning.
like I said, the information is easily obtainable.
So you should have obtained it.
I should have the information in the mailroom right now
You should have obtained it then.
that you can readily view
The
this
fact
information
that your
about the class
investigation
action
was
lawsuit about the
behind
recall. It wasn't just the
isn't a
2010
violation.
model
This is
in question.
your
It was
fault.
2008 through 2010.
Except nothing's ever his fault.
The information about the malfunctioning pertains strictly to the throttle body.
Not the
Let me
brakes.
address your claim, sir. So, not trying to cut you off. I don't need the specifics about a class action because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine
Did he
the
say he bought it
inspector
at the
regarding
dealership?
his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls. And more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email. It's one page with what you said. I have to turn my head. I got to figure out how to flip it. So give me a second.
Okay. And just for the record, Your
Hold
Honor.
on, let me finish my record, okay? So I'm going to turn because it's the only way I can read. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital.
Once again,
So I
You
understand the information
should
that you're
have
providing me, but
found
again,
it
you had a full
before.
and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother. And from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the
Exactly.
recalls and what to do.
I mean, assuming the
And
recall
presumably
happened
she
during
would have
her
provided that
ownership.
information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated
Besides
that
which, if she
did
did nothing
anything
and
with
it was
or
a
not.
cause,
The bottom
do
line
we
is
add
there is
her
absolutely no
to the
Brady
charges
violation by the
for
state. This is not the type of
manslaughter?
information they would have been required to
reckless
turn
disregard?
over. And from my understanding and review of
I mean, it
Exhibit
wouldn't be,
83,
but
what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer
I mean,
of proof.
an
as
actual
to what
expert
would have been the issues
examination
based upon
of the
information
vehicle
provided. And again, without anything further,
is more
from you
accurate
by
than a
way of your offer of
speculative
proof, I
recall
can't
about a
make the
possible
finding, number
problem.
one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to
Yep.
dismiss the case.
And
I'll deny
meltdown
the
in
request to recall this
3,
witness.
2, 1.
Your
Hold
Your
on.
Honor.
Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in
So he's
front
had
of
it for
him and
6
was
months.
questioning, asking questions directly.
And I
related to
remember them
information
talking
contained
about
in
the
that report.
throttle bodies because he
Go
was
ahead.
able to examine them
Yeah,
through
when you
the
spoke the
opening
owner of
and the
vehicle,
crumpled
that's who
hood.
gave me the information. My mother gave me the information of this. I had no
Well, she
knowledge
should have
until
given
she
it
told
to
me.
you last week.
And that's how I came into the information.
This isn't
And she was the one that said,
exculpatory.
I'm going to send you all the information that you need.
You
present
should
it
have
to the court.
investigated before
So I didn't-
trial.
I
This
understand that, sir,
this
but
wasn't
your request
information.
is not timely. So you have had this information for quite some time, either through
I
counsel.
did not have it for quite
Let
You
me
some
make
did.
my
time. It was
record,
just,
either through
through the
it was
counsel.
just told
report.
to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that
lot
may
bit
seem fair
too
to you,
late.
but when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that
Exactly.
you
Your
cross-examined
failure
this witness.
to
It was not
research
readily
isn't the state's fault.
available for me to expect at the time. I don't have access to the internet.
You should have hired an
So
investigator
how
then.
would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
So,
I'm
and I'm
telling
going to
you,
trust.
she just told me this information. I have the phone calls to prove it.
Well,
I
she should have
understand
done
that
it
I'm denying
earlier
the
then.
request, sir.
And I would like a.
So that's my decision.
I
Nothing
object to
has
that, Your
ever
Honor.
hit
I
the
understand.
fault.
I
I've made my
object to that.
decision. I
It's
expect that you
always
respect the decision, at least
No.
that we're not
mountain out
going
of a
to
molehill,
debate it
molehill,
further.
and
Yes.
I
his,
now have the,
he has no
ICF,
responsibility.
It
the
needs to
one
be
for the state to be
addressed, Your
provided
Honor.
for the state.
Yep, we
I'm
know
still
he has a
giving it
tablet
to
he
you.
can research on.
All right, so
I
Mr. Brooks, in
respectfully
light of
object.
that,
I respectfully object, Your Honor, and request the legal reconsideration of your ruling, Your Honor.
it's
Denied.
denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take
Oh, you
exception to that
reject
ruling,
it.
Your Honor.
All right, Mr. Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Maybe if they didn't filter
I
that
provided
out,
an
he
oral
wouldn't be
ruling today, the
so
record states,
tightly
sir.
For the record, may
wound.
I respectfully request a written judicial finding
No,
of
you
facts and
can't.
conclusion of law on this issue?
No,
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
no.
I wouldn't be the one you would make that request to, sir. So I
For the
can't
record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
The
No,
request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact,
it
Your
has
Honor?
Any
no
other requests, sir? I'd
likelihood
like
of
to move on.
success.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been. Your Honor.
The
No,
request is
you
denied.
stating
The
there's a
request is
legal
not a
basis
proper
doesn't mean
motion.
there
There's
is a
no
legal
legal
basis.
support for the motion. There's no factual support for the motion. So it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor.
Oh, in contempt of the law.
Can you show me how or where this court is following the law of respecting this matter?
Can you show where it's not?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court. based
It's
in law
sovereign
or
citizen
fact.
mumbo jumbo.
So this court cannot address that last statement of yours.
Your Honor, with all due respect,
You've shown none. So just stop with the all due respect.
I would
You've
like
shown
a
none.
motion for finding the fact.
Denied.
Under what law fact?
I made an oral ruling, sir. There's no
The
requirement
fact that she
you
doesn't
serve
have to
it.
provide you a written finding of every ruling.
So you're denying a legal, you're denying a motion for finding a fact.
She
Yeah.
doesn't have to give you a written
So how do
finding
I
of
know
fact.
what you're doing is legal, Your Honor?
The trial would never
All right, Mr.
end
Brooks,
if
we're
she
going
had
to
to
move
issue a written
forward.
decision on
At
every
this
single
time, I want
decision
to,
during trial.
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Can you
Mr.
show
Brooks,
that it's not?
We're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
it
advisements,
doesn't
and I'd
seem like
ask that you
I
stop
don't
interrupting
need your
me.
advice. I need-
No,
You
I'm
clearly
giving you
do.
advisements, sir, regarding
I
your right
need you
to
to do.
testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right
You don't.
to testify.
You don't need
Do you
to
have
go
a
through-
witness
you
to
don't need
call?
Yes,
go
she
through anything
absolutely
with me,
does.
Record. You need
Actually,
to-
I do so,
Actually,
sir.
you
That is
don't.
required by law.
Absolutely
You don't.
does.
You need to do your job as a
This
public
is her
servant
job.
Mr.
and
Brooks,
honor the oath that you
I
took,
need to go
Your
through
Honor.
these advisements, and if
She
you're going to
knows
keep
what
interrupting
her
me,
job
you
is
will
a
forfeit
hell of
your
a
right
lot
to be present,
better than
and
So
you
you
you're
will
do.
holding me in
move
contempt
to
again.
the
She has
next
never
courtroom
held
so
you
that I
in
can
contempt.
properly go through these advisements
I
without being
still-
interrupted.
And I still don't have to answer.
This
I
is
still don't have.
regular
to answer
speed
whether
at
I'm
the
in this court or
moment.
not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the
Oh,
options available to this court.
not that she's
under,
finding it right now.
Illinois versus Allen,
That
under
she
State
has in
versus
the past.
Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with
I
all
need
due
you
respect,
to
You've shown
Illinois
none.
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
in Illinois versus Allen.
Mr. Brooks, I'm
Illinois.
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm not
Allen.
trying to have a debate.
You
I'm
are
really
advised
trying
that
to
a
understand
continued,
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying
We'll
that I'm
I've
probably
said
get
that
to
multiple
that,
times.
but
I've given you multiple
for arguments,
opportunities
You're
to
holding
stop
me in
interrupting
I'm at
me.
real
You're holding me in
speed.
contempt
Regular.
Mr. Brooks,
by
I'm not holding
removing
you
me
in
from the
contempt
courtroom.
for the second time here, and I've
Your
also
Honor,
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect,
You have shown
in
none.
Illinois versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this
And once
court
again,
that
understand,
he
He
Your
wants
thinks that
to
providing video
disrupt his
access because it's not
proceedings,
even in
explicitly
mild
manner
stated in
towards
Illinois
race.
versus Allen
I've
I'm
reminded
violate
you
his
of
right,
things
Your Honor,
even though it's
regarding
less
because it doesn't-
restrictive.
and one of the
Illinois
And just
bedrocks
kicking
is
him
that you
out.
not
Illinois versus
interrupt.
Allen does not state
All right, I'm going to
that-
remove him to the next courtroom so that I can go
It
through
does
states
proper
not
that
state
the
advisements with him
judge
without being
can
interrupted.
does
keep
not
Clear the
control.
courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there.
It's
Again, I'll
it
make
doesn't
sure
Illinois
state
that
versus
that
he
Allen
be
is
states you
present
can
is
be
there.
ejected,
or
period.
that you could be
Yes, we're off the record.
or that you
until,
could be
he's in the
okay,
other
so
courtroom. I'll
you're
be
making a
stepping
tacit
off.
agreement.
Ooh, a tacit agreement. Exactly. Exactly. He is so dumb that he doesn't realize he's dumb. But now we can fast forward a little bit. One of the benefits of me being late.
Please get verification that the
All
audio
right.
and video are working in the neighboring courtroom. All right, thank you. I do have verification.
I
There
mean,
are headphones on the table in front of
they
Mr.
won't
Brooks,
even
should
hear
he,
that appeal.
choose to wear them. I see he's reading from a book at the moment. I do need to make a
At least
record
the
that this
Supreme
morning,
Court won't.
although Mr. Brooks was
Illinois
not
versus
raising
Allen
his
being
voice, there were
a
repeated
Supreme Court case.
interruptions. He wanted to debate rulings that I made after the fact. Just this morning alone, about 26, 27 different times he interrupted me or
Ooh.
spoke over me.
27
Once
interruptions
I
already.
made a decision on his motion to dismiss and his request to recall a witness. He then asked if for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He asked for a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer, specifically as it relates to the request for an interlocutory appeal, since I would not be the judge or court to which a request would be made. That is something that would be made to the Court of Appeals.
It would be nice, but
And although I would
at
have
the same
authority to
time,
grant a stay pending appeal, there is no appeal that's
The-
pending.
they're not doing testimony at the moment, so it's easier
I
to
gave Mr.
kick him out
Brooks
quickly.
multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and
Yep.
would be taken to the neighboring
hide
courtroom.
behind that
I
Bible.
believe I gave that warning at least twice.
I mean,
Of
look
course,
at him
this
right
comes
now.
on the record before this court
He's
over the
such a
first 15
clown.
days of trial, where Mr. Brooks has, by his conduct, forfeited his right to be present on a number of occasions due to his conduct. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up
He's
to
not
today,
a child
and
because
knowing what
children
this
can
court needs to
learn.
get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I
listen
need
to
to
it.
have and an advisement of his rights that I need to go through. And I simply am not able to do that with him constantly interrupting me and then not
This needs to be
respecting
interactive,
the oral
and
rulings that are made.
he's not going to
Of
participate.
course, at any point in time, Mr. Brooks can ask to be brought back over to this courtroom under Illinois versus Allen. Of course, he needs to
I
pledge
did
that
not.
he is willing
And I
to
don't
conduct
remember who
himself
Ethan Crumbly
consistently
is. I know
with
the name.
decorum and respect inherent in the concepts of courts and judicial proceedings. I, of course, have repeatedly, even without him making such a pledge, brought him back into the courtroom where I felt a sufficient time has passed. And he, at many times, has
Yes.
been able to conform his
It-
conduct.
I mean,
I
failure
would
to
note
yell
during
and
the
shout
vast majority of the
does not good behavior
testimony
make.
that was provided during the state's case, he was in the courtroom. If not during the entire time, he was able to cross-examine
Oh,
witnesses.
okay.
We had a couple of
Okay.
issues during the testimony of witnesses he called. And of course, last Friday was, in my opinion, probably one of the most challenging days, I should say, to date. It's
Yes.
my hope that we can continue with Mr.
That's
Brooks
one I don't plan to cover.
in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. Mr. Brooks, you have been muted. I will make that, put that on the record as well. I will unmute though and ask Mr. Brooks, because you did not answer
Oh,
the
no.
question previously.
There's no way.
Other
Good
than
morning,
you
Bruce.
potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse to call today? I need an answer to that question, sir.
It is not. Oh, was someone talking to me?
Jurisdiction that we haven't addressed when I was just over here, or since I've been over here? Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not
He
filed
tore it
any
up.
type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
This is the jurisdictional challenge right here. So are you gonna address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses.
He thinks
to
he's
call
in
other than
control here
himself. He has
still.
declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no.
But is that a
And,
tacit agreement
there-
on his
You will
part?
lose the opportunity. You will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted, so I'm not sure. I don't know when you muted me or when I'm not muted.
Well, me muting you doesn't affect you being able to hear the court because
Yes, it does.
that only
Yes, it does.
mutes your audio coming into this courtroom. I confirmed already
Why is my
that
audio muted to begin with?
Because you
that
wouldn't
is simply
stop
a misstatement. I
yapping.
confirmed with the bailiffs that the audio and visual were
Why is
working.
my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be
Has she
assisting
been
with
at
that in
the
any way. You indicated when that
trial
was
at
said
all?
that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning and specifically now?
It's clearly the state's fault that she's not there.
I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning? He's been unmuted though, for a while now. We can obviously hear him. I will ask Mr. Brooks a third time for the record. He's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
Now he's raising his voice.
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual
Stop
courtroom,
interrupting, asshole.
I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the
You
record.
I'm
did!
not lying on the record, sir. I've
You are
confirmed.
lying on the record.
All right, I'm going to mute him once again because now
Gag
he's raising his
him.
voice. Now he's angry. He's thrown the headphones. He certainly does
Bind
not
and
seem to
gag
want to
him.
answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses other than perhaps himself. I then specifically asked him about Dawn Woods because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that.
You asked a lot more
Based
than
upon his
twice.
failure to respond, based upon this court advising him that if he failed to answer that question,
But is it a
he
tacit
would forfeit his
agreement?
right to present any additional witnesses, again, other than perhaps himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct
good way
Mr.
to
Brooks to the case of State
Cut the
versus
trial short.
Anthony, although that squarely dealt with a person's right to be themselves a witness in their own case. They talk at length in that case about how rights
Yes.
even constitutional rights can be forfeited
absolutely
by
can.
conduct. Of course, the right to be present can be forfeited by
He
conduct.
keeps
That was
saying
established
that
in Illinois versus Allen.
presence
And
via
then the right to
video
present evidence
conference
on your behalf
is
can also be
unconstitutional
forfeited based
because it's not
upon
one of the three options in
conduct.
Illinois versus Allen. A
Although
gag
the
is
criminal defendant
allowed
does
by
have
the
a right
Supreme
to
Court
present a
in Illinois
defense,
versus Allen.
doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom.
That's it. Dignity,
Mr. Brooks
order,
has
and decorum.
demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and
Oh,
a
yeah.
disruption tactic.
Clearly, the courthouse food is better than the jails.
When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses. I would like to go through a number of advisements with Mr.
He won't
Brooks
participate.
regarding his right to testify. I will unmute him for that. I ask Mr. Brooks to put on his headphones if he is unable to
Every
hear me,
option
and just to
to
be
keep him in control
100%
has
safe and
its
secure in the
upsides
record.
and
I'd ask the
downsides.
bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point.
The only thing that's interesting about this
He's unmuted.
trial is the circus aspect. There really is very little to
I've
even
also been
discuss
advised
on
by
appeal.
not just the bailiffs who are over there who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear.
He has to be in control.
Mr. Brooks, I would like to
but
go
the
through
thing
with you
is,
your right to testify and your right not
if
to
he has
testify.
a public defender for
We're
his
at the
first
stage of the
appeal, I don't even have to
proceedings
talk
where it
to
is
him.
important that this court
It's all
conduct
from
a
the record.
colloquy with you. I will advise you that if you refuse to answer my questions, refuse
sucks,
to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin, 20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on.
He heard it.
Has a book in front of him.
He heard
although
it.
I haven't seen a page turn.
If
If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that?
I love that she called him out for not turning a single page in the book.
No response by Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that?
His hearing's selective, so no.
Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by
He's not
Mr.
going to
Brooks.
respond to any of the advisements. She'll
It's my
say,
understanding that Mr. Brooks has the
she'll
equivalent
say,
of a
all
12th
right, you
grade
decided not to
education,
testify, and then he'll
that he attended school
claim,
either
how
up to
dare
or
you,
through
I want
12th
to
grade
testify.
and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have
At this point, they
a
might
high
want
school
him to
education.
just,
He is currently in custody.
because they know
of course,
he's
at the
a
Waukesha County Jail. I'm not
jackass.
aware of any medication that he has been taking. Sir, have you taken any medication?
I mean, they've already
within the last
been here
24
for,
hours or any drugs or
2
any
months.
alcohol?
Well, almost a month.
I'm not receiving a response to that.
What's another
I'm
day?
aware that he's able to read and write English. I would refer back to
Well,
the record
kind of
made
read
during
and
my
write.
colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Stop interrupting.
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you gonna verify it on record?
Seriously?
He did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24
Exactly.
hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify
Oh,
on
he's
your
going to like
behalf in
that
this trial?
question.
Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
You absolutely do.
I don't hear everything you saying, and you know I don't hear everything you saying. So cut the crap.
Mr. Brooks has interrupted with very disrespectful words at this moment. I believe that he is feigning his inability to hear, and that
Oh,
he's
yeah.
done so throughout this case. There's absolutely
I
no
believe so,
indication. He
too.
puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom.
It's all
But
performative.
again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio, are simply false.
So
Mr. Brooks, have you made?
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here.
Well,
That's what I said.
you're
So I
not
would appreciate if
listening.
you would make the record clear and correct.
He doesn't know what's going on
Clearly,
between
he heard
your
me say
ears.
that for him to make that distinguishing
Yeah,
statement.
I'm sitting right
So-
here. Don't you see me looking all up to the microphone so you can hear me?
I don't have an issue hearing you at all, sir.
Can you hear me when I'm right here?
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
Now, have you made a decision to tell
I
me?
will ask you again, sir.
Jurisdiction?
Have you made a decision to testify
Have you made a
in this
decision to
case?
address subject matter jurisdiction? Have you made a
He's
decision
already put it on the
to be
record
impartial?
100
To answer what your
times.
name is? To answer if you have a claim against me or
I'm
don't
going to
you
mute him
have a
for the
claim against
moment just because once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me
The
about subject
closer-
matter
The
jurisdiction.
closer the
He's
verdict
making
gets,
statements
the
about this
worse
court
his
that are
behavior gets.
disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them. I will unmute him and I will ask him for a third time with the understanding that if he fails
I mean,
to answer the question in the affirmative, I will
she
interpret
maybe
his
needs
failure to respond
flowers
as
sent
a
at the end of the
no,
trial
and
or
that he is not
something.
going to testify. So once again, I
She
am
definitely
unmuting
needs a
him.
vacation, though.
Sir, Have you made a decision on whether to testify in this case?
Clearly, the Bible's more interesting than that
There's
question.
no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want to,
How long have I been unmuted? 'Cause you just
sir,
said
do you want to testify in
you
this
just said you
case?
was muting me when I had the headphones on just a minute ago. You just said you was muting me. So when have I become unmuted? Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one last time. Do
didn't
you
ask
want
me
to-
nothing because I haven't heard nothing that you asked. So how you gonna ask me?
Well, then listen.
You didn't just answer for me.
Mr. Brooks, do you want to
You can't answer
testify?
for me.
All right, I'm going
can't
to
answer for
answer. I'm going to
You
mute
can't
him
answer
again.
for me.
Again, it is
If
very
you would
clear to this court
listen,
that he uses the statement that he can't hear as a means to delay. It's a distraction.
exactly.
It's very evident that he
The judge
hears
isn't
this court and that
stupid.
he's choosing to willfully not answer this court. This court, as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple
He's
questions.
refused to listen.
I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum.
Don't
Again, ensure
know.
relevant
Static.
and admissible evidence is presented, and also honor the defendant's right.
I don't
to
think there is
present
in
a
StreamYard.
defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial. His repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom, because this morning alone, he is yet to conform his conduct to the simple standards of courtesy and decorum that are required of all participants in these court proceedings: the court, the prosecutor, the defendant, the jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court regarding his right to testify. I am unmuting him and will attempt to go through this procedure.
Not gonna
Once
work.
again, if he fails to answer these questions, then he is forfeiting his right to testify
I thought I smelled a
by
sandwich.
his own
Static.
conduct. I would acknowledge that such a
What kind of
procedure
pocket
is certainly
sandwich do you have in
not
there?
ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr.
She just
Brooks,
told
are
you
you
she-
aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
No, she is
Mr.
not.
Brooks, do you understand and are aware that you have a constitutional
I
right not to
understand.
testify?
Practicing law from the bench.
Are
Standard
you aware
sovereign
that you have a
citizen.
constitutional right not to testify?
I don't understand, and I'm not aware, so why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify and that if you choose to
I don't
testify,
understand.
that you would be subject to cross-examination by the state. Did you hear me say that?
I didn't hear you say anything. I don't understand what you're asking. I don't
He is
understand.
willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying to.
Did you hear me say
You
that?
have shown no respect.
I didn't hear you ask me anything.
He's shown no respect.
And I
Sir?
don't understand.
Stop talking and I'll ask it again. Sir,
Can you ask me to stop talking? And
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I
He
will
still
attempt
thinks
to do
he's
this
in
one
control.
last time.
Yeah, I can hear him. I got the headphones on.
All right, then let's,
Obviously, you can see that.
once again, Mr. Brooks is being disrespectful. He is
That's not being
blurting out
disrespectful. I'm
information.
saying
He
the
reverts
fact.
back to subject matter jurisdiction. He
stating the
accuses
fact.
this court of not honoring its oath. He just accused me of practicing
haven't.
law without a license. Again,
You
all
No,
attempts
I said
to
practicing law
deflect
from the
away.
bench. I
I'm
said
going to mute him
practicing
once
law.
again. This court has simply tried to no avail.
She's
to get
gonna
Mr.
shut it
Brooks
down
to
before that.
answer simple questions, confirming on the record that he has been advised that he has a constitutional right to testify, and that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure.
He hasn't read
He
those
would
anyway.
not even answer simple questions regarding his right to testify and whether he heard that or not. And based upon pursuant to State versus Anthony, and looking at the balancing test that this court must consider,
We have Satsuma plum trees.
this court simply
They
cannot
give plums about every other year, but they're
allow
so
Mr. Brooks
good.
to get on the witness stand unfettered without an acknowledgement that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I've provided the legal basis on the record, or in the case of subject matter jurisdiction, even when there's a written determination on the issue. When looking at State versus Anthony, this is a case where the Wisconsin Supreme Court was faced with a similar situation, although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has
Satsuma.
a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply
Obstinate even.
wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence
He
and the
thinks
rules
he's
of
in control.
procedure. As State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Those restrictions, again, fall primarily under the rules of evidence and the rules
Like,
of
he can't
procedure.
get up and misstate the law and start gibbering
The
about
court in Anthony
subject matter
cited
jurisdiction.
the U.S. Supreme Court from Arkansas versus Rock, wherein
I thought I
that
saw
court
his
stated
guitar
the right to present
behind
relevant
counsel
testimony is not
desk.
limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process. For example, numerous procedural and evidentiary rules control the presentation of evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that a defendant may forfeit his right to testify by his conduct. Whether a criminal defendant may forfeit his or her right to testify through conduct incompatible with the assertion of a right was reviewed by that court. That court went on to discuss waiver and forfeiture and ultimately went on to conclude the following. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. The balancing test that this court must go through are the interests, again, as I've already stated, for the rules of evidence, the rules of procedure, civility, and decorum.
He doesn't
and
know what
balancing all of
civility and
that
decorum
against,
are.
Mr. Brooks's right to testify. This court is not making an arbitrary decision. The decision I make here today is, in my opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout this
I mean,
trial,
his
and
failure to
specifically
even
today,
respond
based upon his failure
to her
to
questions.
even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer the questions would be taken as by this court really as no.
The problem
meaning
with that
a
is
specific question.
he already
having
has
made a
the
decision,
404
and is
no
for
brain
all of those
found
reasons
error.
that this court will make a finding he has forfeited his right to testify. With that, then, there are no other witnesses to
All
present
right.
for the defense. Before I bring the
So
jury
defense
out,
rests.
I'll ask the state if you intend to call any rebuttal witnesses.
We have no rebuttal case, Your Honor, thank you.
All right.
I wouldn't have thought so.
I would like Mr. Brooks to be brought back over so that he is present in the courtroom when the court advises the jury that the defense is resting. I realize that will be over his objection. I'd ask that he honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence
he's
of the
gonna
jury,
challenge
I will
it.
bring you back over.
He's going to have an unholy
for that.
meltdown once the jury's
Are you
out.
willing to make that pledge, sir?
Make what pledge? I'm not making no pledges.
Sir,
You're trying to, you asked me a question, now I can't answer.
yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent.
No, she's trying to coerce you.
How can you coerce
into
me
behaving.
my right to remain silent?
Good morning, BB.
So you're not gonna protect my constitutional rights? Because I didn't answer nothing that you was trying to answer.
Which is a
before.
tacit agreement by your
You
rules.
can't make a decision for me.
By your rules, it's a
do that.
tacit agreement.
You're violating my constitutional rights.
No.
Sir, if you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
When I know, you can't tell me what I decided to do because I didn't decide to do or not do anything.
And since
Are you
she
willing
can't
to-
force you
Right.
to testify,
Well,
your failure to
coerce
respond in the
I'm not coercing
affirmative
you,
is
sir.
waiving it.
well, you're making a decision for me based on something that I did not say myself.
Well, then you
Last
should have
Friday, I
participated,
specifically
dumbass.
directed your attention to State versus Anthony. I discussed very briefly at the end of the day on Friday
Exactly.
the case law that is relevant on
Right.
this
You
topic,
remember how
including
much was
State
going on
versus
Friday?
Anthony, Rock
You
versus
remember how much was
Arkansas,
going on Friday?
and Chambers versus Mississippi to specifically put you on notice.
Did you recall what was going on Friday?
Yeah,
Mr.
you
Brooks,
were
I'm gonna make-
extremely
again,
disruptive.
I'm not going to have a debate. I've made a finding.
3
I've given
hours
him
of
yet
arguments
another
with you
opportunity.
on
If he's willing
Friday.
to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent. His lack of consent to this entire procedure is noted for the record. Based on his inability to pledge to this court that he will honor that ruling and be respectful of the jury, I'm going to leave him in the
Or
other
even
courtroom.
to
The jury is
acknowledge
going to be brought out,
anything.
and he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom and that his appearance from the other courtroom should not in any way be held against him or influence their verdict in any way. I will tell them that there are no further witnesses for the defense, and then I'll ask the state if there is any rebuttal, and then the jury will be excused for the day because we will have I anticipate will be a very lengthy discussion on jury instructions.
Lengthier if he's not muted.
Again, I will advise Mr. Brooks that if at any point in time he wants to come back over, he needs to advise the bailiffs, but it does need to be accompanied by a pledge that he will follow the rules of civility. and
Well, I
decorum,
mean,
and
it
he will
wouldn't be
not
a
specifically
monologue.
challenge
I'm
the
sure it would
court's
be
rulings
objection
regarding
city.
closing off
but-
of his ability to call witnesses. Or
His
testify
closing
on his
argument
behalf.
will be quite a monologue,
All
I'm
right,
sure.
let's have the jury brought out.
Of course, I thought his opening would be too, so. What's he confused about now? Yeah, gesture and what's going on? If you were listening, you'd know. I mean, he's got his mask on, even though there's no one around him. The deputies are clearly a ways away. It's not that I can lip read anyway, but when he's muted and masked, it makes it difficult.
All right.
Except for shoveling the snow. That counts as yard work. But it does look like a nice, clear blue sky outside now, so.
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way and must not influence your verdict in any manner. At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day so that the parties and I
And I'm
go
sure
through
the
all
jury is
instructions And I anticipate
Super
bringing you
excited
in
to have
tomorrow
shown up
morning.
today just for
Instructions may very well
2
take
minutes.
most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not by tomorrow evening, sometime Wednesday morning or early afternoon. With that,
Do we
all rise
think
for
he'll
the jury.
actually
Then please
allow
turn your
closing
notebooks
to
in
happen
to the
tomorrow?
bailiffs. They'll get them back to you during deliberation.
I think the good amount of snow is adding a heated driveway and enough snow to keep the grass covered, but not to overwhelm the heated driveway. I'm not at that stage in life yet, though.
Thank you. Be seated.
But we're in such a terrible
Before we
drought out
begin,
west
I will
that
have
I want
Teresa
lots
print
of
off
snow.
what at least we do have for both parties. I'd like to take a short comfort break. I'll invite Mr. Brooks to come back over, and then we'll start with that jury instruction
Yeah,
conference. We'll take
she's-
about 10 minutes.
she's done
Thank you,
with him.
everyone. We are in recess.
All right, I'll be back in a minute. Then I'll fast forward and go to a slightly faster speed. So, morning, Empty Woods. You missed a show, but I'll be back in just a minute. All right, I'm back. And the problem with 4x4, Steve, I still have to walk on the snow, and that's, shall we say, difficult with one leg. You know, if I don't step down just right, the you know, my knee is, it's hydraulic, but it is just a hinge with no muscle, and if I don't step right on the ice, it takes me down. So, and yeah, I've actually read about that, BB, about the Iceland utilizing the geothermal heat to heat sidewalks and houses even. Um Here in Utah, there's actually talk about building some geothermal power plants. There's an area, I think, in central Utah that's apparently great for it. But yeah, our winters have just been pathetic recently. So we just we as much as I don't like October snow, I'll take it. We need it. Well, I mean, so no jury, no prejudice. I think most of the rest of the day he's just going to be in the other courtroom. She's trying to bring him back, she said. I think she's gonna just have him on mute. Except this is something he needs to participate in. The jury instructions are not the most exciting thing in a trial. We already heard the preliminary jury instructions that took most of the day before the state opened. Um, if he doesn't participate, he waives his objections. And so this is, I think, going to be, well, with a defendant that is capable of good behavior, this is the most boring phase of trial. He's incapable of good behavior, so it could be fun. I still think, as a timeline for today, I'm going to go to 1 1/4 speed once I fast forward. And then after lunch, well, I'm basically, I think I'm going to take a longer lunch than normal just to be able to go at a faster speed after lunch too. So, and that's actually walking like a penguin. The trick is you never put your weight in front of you. You always step down with your weight going directly down. It it has helped me. And I do you in really bad weather, I use the I can't remember what they're called. They're basically shoe spikes that, except they're not spikes. They're like coils, and they help walking on ice. So, um, and I think she said 69 pages of jury instructions. So, with that, let's fast forward and go to 1 1/4 speed.
On the record, appearances are as they were before. The record should reflect that Mr. Brooks continues to appear from the other courtroom.
I didn't
would
think
like
he'd
to make a
be
record
back.
regarding the audio and visual from the other courtroom.
He does
I've
have his
asked that
headphones
one
on.
of the bailiffs who was present during the last session, present in that courtroom, come to this courtroom. I'm going to put him under oath and have him testify about the audio. I also have
Oh,
information from Zach Tremaine, our IT specialist. He too will take the witness stand. And I just want to make a full record.
they're not
of
taking any of
did a,
his nonsense.
decibel reading regarding the audio as well. All right, we have Deputy Kibler. If you could take the witness stand, please.
He's claiming he couldn't hear in there. The
Sir, could
deputy
you please raise
says
your right
the
hand?
audio's way louder
You
in
solemnly swear
there.
that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth. Thank you. Please have a seat. Please state your first and last names for the record.
First name is Nicholas, last name is Kibler, first name Nicholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
She did.
I am.
She said she
And have you been
struggles
assigned to
with
work
12
this case?
point.
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And did you make any personal observations?
That's
regarding
why
the
it's
audio and
important to
visual,
read court
setup
rules.
that we have
Some
over there?
judges
Both
have
the audio and visual
rules that
for
you have to
the audio
submit
was
in a certain font
a
size
lot louder than it has been.
or even certain
Louder
font
than
and
that.
certain margins.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom into the neighboring courtroom.
I could.
I'm not one to
That's the
judge,
only record I wanted to make. State, have any questions?
Just briefly.
unless you're talking
Deputy
about me,
Kibler,
of course.
The defendant asked many times if he was muted or unmuted. Do you remember that?
Absolutely.
Yes.
Can you confirm that even on the occasions when his microphone was muted,
Especially,
the
this
audio
isn't
in
for the
courtroom
jury.
continued to work?
It was.
And at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not.
Now I know
he's
you're
telling us he
lying.
prefers right now to be in
I
the
didn't
courtroom.
put you under oath though, so it's
All right,
okay.
thank you. Those are all my questions, Your Honor.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy?
Nope.
All right, thank you. You may step down. All right, then I'm going to have Zach Tremaine also take the witness stand. Do you have- I have it on my screen. Can you do a project it, please?
Always with a Tremaine as a surprise witness. If you remember, Morgan Tremaine was the
There it
TMZ
is.
surprise
First of all, sir,
witness
stand
in
and raise your
the
right hand.
Johnny Depp trial.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right, thank you. Be seated. State your first and last name for the record, please.
Zachary Tremaine, Zachary. Tremaine is Tremaine.
All right, and what is your position with the clerk of court's office here in Waukesha?
I'm the IT coordinator for the Waukesha County Circuit Courts.
Were you in?
That's quite a
courtroom
ginger
20
beard
this
he
morning
has.
Following Mr. Brooks being taken to that courtroom?
Only temporarily, I was there when the call started, and then we came back to do a measurement of the DV meter later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo, overlaid on top of what we call the X panel. That is our AV control panel. So you push buttons on it and actions happen in the courtroom, AV related. At that time of the photo, my phone is registering 67.
There were limited
in that courtroom,
options.
and that was when the judge or the court was talking, and then the sound was coming over the speakers in the other courtroom.
And what, if anything, based on your training and experience, can you tell me 67 decibels means?
It's plenty loud. For comparison, I did a quick reading in the media pooling room, which is CG6 in our courthouse. The meter there was reading between 55 and 65. So it's louder than the audio feed going to the media right now.
They're
All
not
right, thank
giving
you. Any
him
questions,
any avenue
From the
to
state?
appeal.
Sir, I'm looking at the photo, and Your Honor, for the record, this photo will be
I
made a
mean,
court exhibit.
If
Yes.
he goes to the appeals
I'm
court and
looking
says,
at your
I
phone
couldn't
screen,
hear,
and it looks like in the
therefore
upper
I didn't
right-hand
receive
corner,
a
you-
fair trial.
It appears the time's either
This is on
9:26 or
record.
9:36 a.m.
On my phone, yes, I believe our AV processor, which is the other time of 9:23, I believe that just needs to be updated, but
Okay,
it is approximately 9:26 when the photo was taken.
those are my questions.
All right, thank you,
Wait,
Mr.
I'm sorry.
Oh, go ahead.
Morning,
Do
Teresa.
you happen to know what the decibels are in this room?
I don't. I'd have to pull the same thing up on my phone while people are talking.
Thank you.
Mr. Brooks, any questions for this witness?
For the record, I don't consent to being called that name.
That's nice.
Do you know anything about the hearing when someone has the hearing loss in any of their ears?
I do not.
So it'd be fair to say you don't know.
I
if
mean, the
can hear
deputy
everything
that
from his courtroom.
testified
I can
does
tell you what the
look a
readout of
little
the room
bit
is.
like Mr.
Beyond that, I
Clean,
don't
so it should be squeaky clean.
I can see with photo that everybody else is in there seeing that was supposed to be that exhibit. I have not viewed that, so I don't know what's being referred to when you refer to the picture.
I'll have to show you that in a different way. I don't have the Zoom up and running, which would have been the mechanism to allow for an exhibit to be displayed. I can start that and have that up momentarily. Fair enough. So give me a moment. For the moment, we'll print it in black and white so you have it until I can get the Zoom up.
They were planning on you being, you know, in the courtroom so you could see it. Just cold weather here. The snow's creeping down the mountains, but I'm not quite high enough. Static, though, says he got some. Exactly. He hears what he wants to hear.
Sure.
You are in the meeting now.
Whoa. Apparently we're in a
I need to
meeting
get the
now.
other courtroom in, so just one moment.
It's warmed up a bit now. My computer said 34 when I started. It says 36 now. But it is a nice blue sky out,
Well, I have to
so
stop the Polycom, Zach.
Yep, you have to hang up and then join.
after
Okay, hold on.
2
please.
days of rain and a real windy Friday before that.
Stop the call for Polycom to Polycom, and then I'm going to call it in through the Zoom so I can share the screen with the exhibit, which will actually help when we do jury instructions. Yep. Except now both room systems are out, so hold on. One more.
And the Oakers, for those of you who don't know, that's the mountain range on the west side of the Salt Lake Valley and the east side of the Tooele Valley. And Static's on the other side of the Oakers.
You are in the meeting now.
All right, so the record should reflect
I'm on
that
the foothills of the Wasatch Mountains.
I've now changed the audio visual from the Polycom unit to the use of Zoom. I've called in both courtrooms and they can hear from over there. And then I'll do
Paralegals and legal
let me
assistants,
get back on so I can get the email.
I
Give me
think.
a second. I have to go from double screen to single screen.
I'm pretty sure
When I
the
sign in, but that'll take me just a second.
the
and then I'll
woman
share
with
screen so
the
color
very
exhibit
short
can be viewed
haircut,
by-
they've mentioned that she's a
defendant.
paralegal, I think. Did you hear the plane crash a couple days ago, Teresa? I imagine it was pretty noisy, depending how close you were.
All right, now the court is sharing screen and the image is being displayed.
In many countries, that's what it would be.
You see it? Okay, thank you. Any questions regarding that then, sir?
My question was, pretty much already answered. You don't know if me, myself, can hear everything good in the courtroom, correct?
I do not, correct.
He doesn't know what goes on between your ears, other than it's empty in there.
Okay.
Okay, thank you, sir. I'll stop sharing. Okay, thank you, Zach. You can step down.
Warning sigh.
All right, I just wanted to put that on the record since that was an issue raised by Mr. Brooks previously. Now, I need to get a
One of
copy
my
of the
Law school
jury instructions.
classmates
They were quite lengthy. I
lives
wanted
right
to
there at
reflect that
the
Mr. Brooks
mouth of,
was provided with a written copy. It's
Weaver
170 pages,
Canyon.
and the state was provided with a written
and so
copy
she
as well.
posted
Again,
about it on
it's all the same
Facebook real
170
fast.
pages, and then my written copy is on its way.
Exactly. It's all performative.
That's if I'm not muted.
You're not muted.
I also would like to, again, ask for subject matter jurisdiction proven on the record.
Your request is denied.
That's yet to be verified. It has yet to be verified.
How the hell does he think it's
Your request
verified?
is noted.
Your Honor,
It's denied without further hearing or consideration.
I mean, she gave a written
told
ruling even.
that,
What's
every
verified
issue is
proof?
supposed to be closed. How come I haven't been able to present my evidence into the record as I
You
asked
waived
numerous
it.
times on the record
You
to be able
waived.
to do? I
Your
said I have
failure to
numerous documents
respond
that need to go into
waived
the record.
that opportunity.
Why have they not been permitted to be made evidence?
And your filings are not evident.
I didn't rest my case, so I don't know why that's being told. And I have yet to be able to offer my exhibits into the record for evidence.
Your exhibits.
How's that so, Your Honor?
So the court did declare the evidentiary phase of this trial closed.
Yeah,
I
he
specifically
hasn't
found that you
behaved
forfeited
at
your right
all.
to present any further evidence or testimony.
He
You
wouldn't
failed to answer my
respond
questions
to
regarding
the
the following
judge's
witnesses.
questions
And then I also
about whether
declared
he
that you forfeited
testified.
your right
So
to
she said,
testify.
"All right,
Specifically as it relates to your
testimony's
trial
over.
filing, sir, I would note
Defense
that
rests."
all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for
Exactly.
that reason, I'm denying your request to make them part of the record.
Exactly.
They were not hearsay, Your Honor.
They
I did what
are
you told me to do. You
hearsay.
told me, since I was representing myself pro per, that I had to write everything out and present it to the court.
So that's not what I said. You're misquoting me, but in any event, I'm
No, that's
denying
what
your
you said.
request.
Besides
I
which,
said
you're saying
you
that I
would have
have-
had to
So you're saying that I have no
testify.
right to present evidence and to have exhibits as the state's been able to do.
Mr. Brooks,
Are
I'm
you
not
denying
going to
me?
have a
Wait.
debate about this
Are you
now.
denying
I
me?
have,
Are you-
I got
are
to
you
mute
denying
you one
me your
She
right?
second.
tried
Mr.
to
Brooks, I
get
have
you.
muted you because
She gave you every
I declared the
opportunity
evidentiary phase of this
to
trial
present
closed.
evidence.
You
That would
forfeited
have
your
been
right to present
testifying.
further evidence and testimony previously by refusing to answer the
Keep
court's
shouting,
questions. I will
jackass.
specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number two,
It's hearsay.
filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific
But those
relief.
motions
I'm well aware
are
that
not
previously
evidence
he
for
has
the
referenced
jury.
he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay.
Exactly.
Mr. Brooks would have needed to testify regarding any statements that he, from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those
He needs
filings
Blue
that
Bacon's big
he hasn't put forth
bopper.
any exception to
not
the hearsay
inflatable.
rule that would allow this court to admit his written filings. I believe
And you can still see
without
through the
fail,
mask.
they are
He's
all
still
irrelevant,
yapping.
not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions.
He's not.
When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him. so
That's
that
kind of
we
what
can
I
give
was
feedback
thinking when I said
regarding jury instructions. It's
she needs
typically a back
Blue
and
Bacon's
forth. We'll go
big
through them.
bopper.
Um,
For those of you who don't watch,
I'll ask
Blue
the parties
Bacon has
whether
a
there are any instructions they believe should
giant
be included, and we'll have a
inflatable
discussion on that,
hammer
and then we'll talk
that
about
he
whether
uses
any
to
of the
hit his,
instructions that are in here
he's got a little
need to be modified in any way,
bullshit
taken out,
buzzer.
edited, etc.
Beauty.
Right, you're unmuted now, but but you have to not interrupt.
No, you can't.
She
I'm
also
not trying to
needs
interrupt. How
Blue
can you deny
Bacon's
me a chance to put on the
bugle of
action to defend my
baloney.
man? Nothing that you told me to do can be presented into evidence. So you filed them. You filed everything that I gave to you. You
Right,
filed.
Mr. Brooks, I'm going to mute you because this is not relevant at
It's
this
going to
time.
take all
He's
day to do
raised tone of
jury
voice.
instructions.
He's very animated. He threw the jury instructions on the floor. I understand you're
So
upset, sir.
closing
I understand
probably
you believe
tomorrow.
I'm
at
violating
some
your
point,
right to present a
I
defense.
hope.
I've made my rulings. I determined you forfeited your right to testify.
She tried to
which
give you
includes
every
the right to
opportunity.
present evidence as you would have testified. I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that
hear
I'm
me
not
out
without
here.
authority to do that. I made
She could push the
specific
button
factual findings. I've referenced
on
the law,
his
and you being
ankle
upset with the
zapper.
decision is not going to change my mind.
Go
He's also
P.
taken the
Barnes on
headphones
his
off.
ass.
It's his choice right now whether he participates in this jury instruction.
It'll go a lot
conference.
faster if he doesn't
It is his
participate.
choice. But if he is going to spout off about things that I've already determined, I will continue to exercise
misstate
the mute
what
function
she's
on the
determined.
audio equipment. I'll unmute him again, but you are advised, sir, you need to be proper. You need to not interrupt, and you need to stay on task, which is we're discussing jury
I
instructions.
don't actually
not other
know.
evidence, not subject matter
It's
jurisdiction.
possible both of
Not your
them
belief
have
that I
it.
told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
No,
You need to tell me why I can't present evidence.
because you forfeited
How
it.
can you deny me my right to present evidence?
Right?
I
I'll
told
unmute
you
him
before
once
you
again
You wouldn't
because he
respond
wants to
when she
continue.
asked
Again,
you.
I understand he's upset. I understand that. But he has himself to blame for his conduct this morning and the rulings
You
that
were
I've made. All right,
performatively
so let's
ignoring
go through these
her.
jury instructions. First of all, has the state received a copy of the draft?
Yes, Your Honor.
Thank you.
You've never seen P. Barnes.
Mr. Brooks, do you acknowledge receipt? I believe you
we-
did by acknowledging it
okay,
previously, but do you acknowledge
remind
receipt of
me-
the draft of the final jury instructions?
When it goes
I
to
ain't
lunch,
acknowledged nothing, and I don't
remind me
acknowledge
to
anything
play the
now.
P.
I have not
Barnes
received
video.
anything.
I would ask the bailiff to
I
pick
don't
up the
see.
documents from the floor and put them in front of him.
And
once again.
I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on the defense. How can you tell me when
Because it was a
I'm gonna do it once
tacit
again,
agreement
because again, I
on your
understand he's
part
upset.
not
If the
to.
bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him,
Exactly.
but it's by his own conduct that he's done
Exactly.
that.
He
The record
fucked
should reflect
around.
Mr.
He
Brooks is
found
muted because
out.
he wants to continue to debate with this court about my
He still
prior
doesn't
rulings
realize
regarding his
that he found out.
forfeiture by conduct of his right to present further evidence on his behalf.
As Blue Bacon's jingle says,
I know one of the
P.
things I probably
Barnes
need
is
to look at,
our
I'm not sure if
Lord
Madam
and
Clerk did this or
Savior,
not, would be the
Taser
language
Daddy.
from the amendment from the
P.
amended information
Barnes.
on count.
At some point, I want to just make the drive up to Coeur d'Alene and shake his hand.
No, I don't want to do that. What do you got? I changed.
Oops, sorry.
76. The 76 count. Just want to make. It
Yes.
says near Frank Park, so it is in there. But that was just
Brooks
one question
threw
I had.
the jury instructions in the trash. The deputy took them out.
So, state have any requests as it relates to the jury instructions?
Your Honor, I'm just going through each one. I'm on page 50 of 107.
Oh, so they are
Everything's looking great
107
so far.
pages.
Okay.
I thought the
Fair
judge
enough.
said
There's 107
69
I
pages.
certainly can give the parties some time to continue to read through them.
Oh. He's hiding behind the evidence boxes. The Bible's not enough to hide his face. Now it's the evidence boxes. And he can't see the screen. He should put iron bars
Mr. Brooks
around
is
his
requesting
port.
to go back to his cell. At this point, I'm going to deny that request. He can remain in the other courtroom.
I only have a very short clip of the original P. Barnes video. Oh, he's mad. And just you can just barely see the top of his head. But he's moving once again at 1 1/4 speed, but he's so agitated still. He's so mad. I mean, the question is though, are the fort's windows tinted?
I know he's muted, but I can certainly hear him from this side.
Oh,
Appears to be
yeah.
yelling at the top of his
I
lungs.
heard the shouting
I
coming
can't decipher
from
what he's yelling.
these microphones in this courtroom. You can hear him. He's still shouting. I think Artie is the only other one that covered the first
I'll
one I
advise Mr. Brooks,
did
without a
with
specific
the
waiver
singing
of his right to
moron.
be present, even if it's from the remote courtroom, he's going to remain in that courtroom.
I got both of those from
That would
the
require him to.
North Idaho
follow through.
Exposed or whatever it's called. They're a channel that sucks up to Ammon Bundy. They're awful. He pretty much is like the mascot, the hero of the community that makes fun of sovereign citizens. And so is Lieutenant Cochran. I haven't seen the Lieutenant Cochran video in a long time, but he's a lieutenant down in Texas that just did not care, and he barehandedly pulled down a sovereign citizen's window, shattered it with his bare hands. He's still running for governor, though, and as I've said many times, maybe not on my channel, but Idaho exists to make Utah look
Mr. Brooks, I
sane
know
by
you are
comparison.
still muted by me, but I know the audio is working, but I would ask you to
Hence, Ammon
specifically
Bundy
advise if there are
moving
any
from Utah
specific
to
jury
Idaho.
instructions that you are asking be read to the jury.
I imagine any criticism Ammon Bundy put forth to him would be he's a rhino, because no one is conservative enough for Bundy. Would be my guess. I don't follow him. For my sanity, I try to ignore him as much as possible. I mean, if he's muted, this could go a lot faster. Although they are still going to have to go through
Mr.
them.
Brooks, if you have specific instructions or categories of instructions that you believe this court should consider, I need you to write them down on a piece of paper. If you don't have, I believe I see a writing utensil. I'm not sure if I see a pad of paper. We'll make sure you have that. But given your current demeanor, which is still seems quite animated and a loud raised voice, I'd ask that you write it down.
I mean, it's an unfortunate fact that the U.S. agriculture industry is reliant on migrant labor, and the funny thing is, there was a time when the migrant workers would come up for the season, work, and then go back to their home country, usually Mexico, and because they could cross the border easily, but now that they have to sneak across, they stay. So I've actually read studies that show the harsher border controls actually result in people coming over to stay instead of traversing the border back and forth to do seasonal work. Of course, I'm far from an expert on that. That's just a study I read, so I can't say for sure.
How's the state doing on its review? Okay.
All right, at this point, I'm going to 1.5. Yeah. I mean, the things his dad said were pretty bad. What are the bets that Brooks is even looking at the jury instructions in his fort there? Looks like he's shouting at the bailiff. That's why, like I said, I'm glad we're behind so that we can go at a faster speed. And I think I'm going to take like a 2-hour lunch or something so that I can come back after lunch at a faster speed. He's looking at the ceiling and shouting. I mean, you can still hear him.
I just want to make a continuing record that Mr. Brooks is still, I can still hear him even though he's muted due to his level, his tone. Of
You
voice
can
and
hear
volume
him
level
through
that
the
he's using from
walls.
the neighboring courtroom.
I hope there's no other trials going on that floor. I mean, at this point, he probably just needs to be taken back to his cell. He requested it. The judge denied it. He probably just needs to be taken to the cell.
So all of these should be included, but they just put them in numerical order. So,
The ceiling boxed him in.
there are numbers. Well,
It was a nasty ceiling that probably caused this whole thing in the first place.
Which it's before defendant elects not to testify. We toss up that one. Yeah.
No,
Mr. Brooks, I'll advise you once again if there are any specific requests for
I
either instructions or
wouldn't
categories instructions that you want
like
this
to
court
give in
consider,
to his request.
please write a note
But if
to pass
he's
to the bailiffs who can let me know.
disturbing other courtrooms, because this isn't the only thing going on in the courthouse today. So, like, if the courtroom on the other side of him is being disturbed, that they need to stop it or gag him. So that's it. If at some point, if he's disturbing other courtrooms, he either needs to be taken to a cell that I assume is behind concrete walls, so much more soundproof, or gag him. That there are ways to make him quiet. Of course, if they gag him, they'd probably bring him back into the main courtroom. And as interesting as it would be to see him get zapped here, I think it's still it's inappropriate because the reality is zapping him is only really appropriate if he's posing a physical threat. That's terrible, Sai. That's terrible. I love it. As disappointing as it is that he didn't testify, I think she still did him a favor by taking his silence as a tacit agreement and shutting him down. I mean, they've all dealt with morons and jackasses before. He may be more uncontrollable than most, but I think for the most part this is all in a day's work for them. The trauma treatment would be, you know, for certain crimes against children.
Words that might need to be removed. But why don't you go through and tell me what requests you have?
Yeah,
We'll go page by page and just tell me what
they're
page you're
just
on.
going through
So I think
the
first
jury
instance that I have is
instructions.
with regards to the bail jumping. I know that we had charged, there's 2 separate felony cases. The defendant was out on bail. And I do believe it would be assistive to the jury to have the specific case number. So when we first talking about 61 of 107, we start talking about the bail jumping, and then we go specifically on page 63 of 107, and when we talk about count 74
Now they're
and
making their
75,
arguments
I
on
think
it.
it might be
So
helpful to put the Milwaukee case number, because they are different case numbers, so they know exactly what they're finding, that he was out on bail and that as conditions of his release. And those bail bonds were entered into evidence.
Let me look at the,
it would have been funny if she had,
And just because I think this was just a
but
well,
I
guess I'll
don't
have
think
you,
she's as
when you
petty
look at
as
the
I
verdict forms
am.
on page 102 to 107 for the bail jumpings. There's verdicts for the bail jumpings for 3 separate counts: 74, 75, 76. I don't think there should not be one for 76. I believe that should be the battery.
that would be true.
Once again, I think she wasn't, at least intentionally, being deferential to him. She wanted there to be no question at the appeals level that he was afforded due process. So at some point, you know, she did crack down more and more, and she's
You're
just
acting like
done.
that, so I'm gonna search and see what the information says.
But
And then I'll
yes,
look at the position on that.
she
Sometimes
should
it's
have
easier to
said,
just list out, I guess, what
answer
the
me now
changes are requested
or
on
it's
the
done,
notes, and then we'll go through
and then
them
held to it
And I don't
instead
believe it
of
was
giving him 2
spelled out in
more
the amended
chances.
information.
Say that again?
I don't believe it was spelled out in the amended information.
Right.
So that would be page 63 of 107, whether or not we want to put the specific case
Yeah.
numbers.
She says tacit, he wouldn't
I'll tell you
know.
right now, I typically like to follow the information from.
And if she
from
said
line to line,
tack
we can
it,
argue that though to the jury, but
it would have
let's go
been
through the list, and then we'll
trolling.
get
Okay.
the defendant's responses if he'd like to get us those, but we'll go through the whole list. So that's the bail jumping.
Yeah, and then with the verdict forms with regards to the bail jumping, just to put on the record.
And that's it.
page
You
102
know,
and
he's
107,
muted
I believe
now.
There's a count
He's
76, which details it as a bail
left
jumping.
to
I believe it
shout
should be
to the
battery.
void.
I did notice on the motive instruction was incorporated on page 5 of 107. And I know that intent is an element of the battery. I don't believe that was incorporated. I mean, usually it's a standalone instruction. I think the court incorporated it with the first degree intentional homicide because certainly that was.
I think that's part of the pattern instruction.
Oh, it is. Okay, then we'd ask for motive. I think that there's a 175 instruction that could be given as a standalone.
I'll look at that. We'll add that.
And then on page 65 of 107, which is the 70, the preliminary instruction, defendant proceeding pro se. There's the standard paragraph, which is the first paragraph listed under this instruction. And then there's an additional paragraph. We are going to object to that additional paragraph. I think it highlights the defendant's bad behavior. So I'd ask that that be taken out.
I've never dealt with a Southern judge. I
I
mean,
made a note of that. Yeah.
Okay, with regard to page 106 of 107.
you know, you like
I believe that those were add-ons at the end of the court.
from the
One of
videos I've
question of her
seen,
spouse.
Yes.
I believe that there was.
Judge
advice should be
Alex
given.
Manning
One of the witnesses for the state
probably
to
would have
testify.
had
He
him
did have
strung
one
up
prior
by his
conviction. I believe
ankles
a
by
witness
now.
for the
But
defendant
I
testified that he
don't
had
know
a
if
number
she
of convictions.
does trials.
With regard to that same page 106 of 107, instruction 141, where identification of defendant is an issue. I don't know if it is an issue. That wasn't raised during the defendant's closing arguments. I'm sorry, his opening arguments. I would know that.
I mean-
note that the defendant would sometimes cross-examine people on if they were able to see the person driving or the description of the person driving, and he would cross-examine them as to
It's
their
difficult
ability
to deal with
perceive that. So I
a
guess that would really
defendant
be up to
like
the defendant
this
if he wishes that to
and
be given.
give him a fair
On
trial.
page 107 of 107,
You know,
section
if it's
172,
in
circumstantial
pre-trial
evidence, flight,
hearings,
escape, concealment, the state that was
it's easy
included
to
in the initial
mute him.
instruction
But
that you
in front of a
requested, and I would
jury,
continue
it's
to request
just,
that instruction be
it is difficult.
It's really just flight, though.
correct.
What's that number again?
172.
Yeah, I know, it's just not there. I saw it, it's fine. It only has to flight. I made a correction on it to find it. All right. So
And I would say concealment to some extent because he took off some clothes that would have identified
See,
him.
that
But again, his running away, he's
That's
trying
just-
to conceal his identity.
that's a
by
jackass
removing some
judge.
Clothing that would have been was identified by many numerous witnesses.
You know,
as him
if-
wearing a hoodie or a light
if
colored.
people are going to receive jail for simple mistakes as a juror, they're not going to take
do you have
jury
any
duty
requests
seriously.
as
They're
relates
they're
to
they're going to
instructions
do
that were
everything
not
they
in
can to avoid it.
The packet that should be.
So
No, Your Honor.
Let me turn to Mr. Brooks just to get whether he
that,
has any.
that's not a
on his
good
list.
judge either.
I'm not asking for a response yet, Mr. Brooks. What I'm asking you for is whether you have any requests for jury instructions, or if in your review, you think anything needs to be changed, deleted, added, etc. I know I'd ask that if you put it in writing, but I'll also give you this opportunity to verbally advise the court and make your request. Do you have
All
any
right, here
requests as
comes
relates to jury
shouting.
instructions, sir? I would know he put two boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off, so I can see the outline of his arms, and I can see the jacket on the back of his chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as it relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
I think
Your Honor, would it be possible for the bailiffs to just move the boxes out?
That
of the table
might
so
be
Yes,
what
I
that-
think
he's
that's
doing.
fair. I'm going to advise the bailiff to remove the box so I can see.
oh,
Mr.
he's
Brooks.
going to be unhappy about
what he's
that.
doing behind there. He has quieted down. I haven't heard him in a while. If you could move the second one because it can interfere with the microphone as well. And the third one. Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury
Apparently, this
instructions?
is an
Any
eviction
requests for
hearing.
Instructions that aren't included that you believe should be included, any edits or deletions from the packet that has been provided to you?
Why we still need to move my box?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or
Hey,
otherwise?
man, you don't gotta talk to me like that.
Do you have any
Clearly,
requests
she does.
First of all,
related to the jury instructions, sir?
It's always good when you start
I got
at a judge with
it ain't like they
first
gonna-
at all.
As it relates to
first
the
of all,
jury instructions, sir, what are your?
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process.
No, she's been too
Mr. Brooks,
respectful.
do you have any
I'm trying to keep track around here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Apparently, this is a tacit agreement to accept the prosecution's jury instructions.
So I understand you may be upset, and I really do, but I've made my determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't.
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him
And
5 opportunities. Mr. Brooks, do you have any requests as it
Generally,
relates to the jury instructions? I'll
generally.
unmute you for that answer.
I can't hear everything you're saying.
In criminal trials,
Mr. Brooks,
you have bad people on their
I know
best
the audio's
behavior.
turned up.
Whereas
I believe you can hear
family
me.
law, you have good
chosen not to put
people
the headphones
on
on,
their
that's your
worst
choice. My
behavior.
final question to you, do you have any requests as it relates to the jury instructions?
This is a bad person on almost his worst behavior.
I just told you, I don't know how many times.
His worst behavior, of course, being
you should put the
murdering 6
headphones on.
people.
What about that? Don't you understand? Did you see headphones? You can see everything. You can see boxes. But did you see headphones?
Have you asked for headphones to be provided, sir?
I should have to ask him. I asked for my boxes to be moved.
Well, you shouldn't have
I
thrown the
believe they took them away
headphones
previously
across the
because you were so
room.
agitated, they were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I'm gonna stop being agitated. That ain't gonna stop. You sit up here and do everything you're doing. And think God don't see what you're doing? You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury
Yeah,
instructions?
I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah, I
it?
got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
He's never going to hear her if he keeps shouting over her.
No, sir. That was all these, sir, and all these. I'm gonna get where I'm going. Try to put on this little act like you're so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful.
That might result in the tasing.
I need to know what your position is regarding the jury instructions, and I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury
Oh,
instructions, sir.
he doesn't know who she's talking to because she said Mr. Brooks.
It's not double jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with? You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb. Twice. I'm already charged with the same count in Milwaukee. This is for the same case. It's the same bail jumping charge. So how am I charged with that?
Are you on
So I'm
trial
not gonna
for it
provide
in
a legal
Milwaukee?
explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
In that case,
What's your next?
if you
What's
haven't
your-
been
what's your
tried
next
for it in
request, sir? I'm noting your
Milwaukee
objection.
or
I'm trying to
convicted,
and I get it out. You always want me to not interrupt you, but you always find a way to talk over me.
she's in
I
control
understand your
here.
position. I'm saying it's overruled.
She is the judge. She controls who speaks when.
That I've already been charged with. That is double jeopardy. You can't charge me for the same exact bail jumping that I'm already charged with. That I was charged with.
Well, once you're convicted here, you can't be
Sir,
charged
the bail
with it
jumping
in
charges
Milwaukee
Waukesha County are
then.
based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay.
That's the distinction.
Again, there is no distinction. It's the same charge.
It's the same offense. It doesn't mean it's the same factual basis, sir.
He is not charged with bail jumping with the data violation of November 21, 21 in Milwaukee County anywhere.
Is
Further,
there?
Double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
All right,
That's
so
a
we've
good
addressed that. So
idea.
what other requests do you have as it
But the
relates to the jury
dog
instructions?
Zoom filter on, or no, sorry, it was a cat. Because that gets him closer to being a lawyer.
I'm already charged with bail jumping for that.
Because as we know,
So you can't essentially
the
say,
best lawyer is cat lawyer.
we gotta charge you
It's a different date of violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
Yeah, but I'm referring to the first bail jumping count. The first. I'm not referring to both of them. I'm referring to
It's almost like
My
you kill
understanding, sir,
one
there's different
person,
dates of
that's
violations
one
as it
murder
relates to that.
charge.
So I've
You
noted
kill
your
two,
objection now
that's
repeatedly.
a
I
second
understand it.
murder charge.
Your request
Separate
to,
conduct.
I guess, dismiss the bail jumping counts are denied.
I didn't say nothing about count. I said one.
Whether it's one count or both, it's denied.
Am I not being understood? You can't charge me.
Exactly.
Twice. You can't.
It's two separate
is not a cat.
cases, sir. There's two.
Isn't that
He's
isn't that
cat
9-
lawyer.
Isn't that the statute? That refers to the double
Right, sir,
jeopardy
I'm not going
clause?
to have an argument.
If
This isn't
only-
fruitful. I
if
I
only
understand
he
what you're
hadn't
saying. You're
been
saying there's going to be
granted
2 counts
bail.
of bail jumping. You believe it's double jeopardy.
Because
I
I'm
disagree with
already
that.
charged
There's
with it. I'm already
separate.
charged with it. I'm already charged with it, though.
This is a
For
circular
a
argument, sir. It
separate
doesn't change the fact that, from my
charge.
perspective, the
It's
2 bail jumping
separate
counts are going to proceed
conduct.
forward. There's been sufficient evidence presented to warrant the jury being instructed.
I mean, should he have
What
only
other-
been
what
charged
other-
with one
What other
murder
requests do
charge?
you have,
You're
sir?
not gonna talk over me. Don't talk over me. Just like you don't want me to talk over you. Just like you don't want me to talk over you.
Then you should
Mr. Brooks, what other
recognize
requests do you
she's in
have?
charge.
And I just asked you not to talk over me. You've been making your record the whole time you've been over here. You had me muted. I didn't see no requests over there. I didn't write nothing to go over there. I let you do what you was doing.
Oh, you
No matter how
let
egregious
her.
and biased it is, I
You
let do
let
what
her do what she was doing.
because we both know that what you're doing is not right.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that. If you can't answer my question, I'm going to move on.
You can't. I haven't given you consent. Just like
All right, I'm going to mute him once again.
Your
He refuses
consent
to
is
answer simple questions
required.
regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly he has an understanding about the law as it relates to that. It may be a misunderstanding about the law and double jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests. If he can stay on topic, I'll mute. I will unmute him again, and
I
he
mean,
can tell me
she
the list,
wants
just like the
his
state went through a list. I need to get through
participation.
their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here's your opportunity to give me your other requests, not debate with me about prior rulings. Go ahead, Mr. Brooks.
Don't sit up here and try to play no game talking about you giving somebody an opportunity because you haven't gave me an opportunity to properly defend myself with evidence, put subject to evidence.
That's not the subject right now.
You told me you wasn't.
You forfeited your right to
Mr. Brooks, do you have
testify.
any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. No, it's not. So please stop being incorrect, Herman. Please stop.
Do you have any additional requests as it relates to the jury instructions?
Yes.
Oh.
That first count 74 bill jumping needs to be dismissed. Can't
Treat him
charge
like the child he
you-
is.
Can't charge you with the same charge twice.
All right, I made a note of that. What's the next issue?
Either one company gonna charge you with it or go, but it can't be both. It's the same. It's pursuant to the
If
same
you
exact thing
Did
y'all-
bail jumping
same
in
exact-
Milwaukee
same exact
County
case.
and
Why would you
Waukesha
give
County,
instructions
those are
to
separate issues.
From another county.
I've made a note of that. What other
There's a
requests do you have?
separate factual basis for each of those charges.
I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is gonna be found a reason for it not to be done. What are we doing here, Your Honor? What is the
Mr.
reason
Brooks.
here for? Why should I be here when?
I've made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
Why are we even having jury instructions? Why do I have to even sit here in this courtroom?
You don't have to.
Because everything
Plead
is done
guilty
without
right
my
now.
anyway. So
Plead
why-
guilty and be
so
done.
why do I need to be here for?
Your objection for lack of consent is noted for the record.
Okay, yeah.
Any other requests, sir?
You talking big game to say yourself enough things. But everything got put up, it has no bearing in your court. None.
All right, I've asked him many times. I've
Yeah.
advised him, and I'll advise him once again. If he fails to
Well,
answer the question,
I
then you
mean,
on. Do you have any other requests as it relates to the
You
jury
may,
instructions, sir?
you state your position,
All right, he.
the
did not answer.
opposition
So I'm
states
muting
their
him again.
position,
I-
the judge
only request
rules,
that he has made as it
and you
relates
move
to
on.
the jury instructions.
If
as
you
he
don't
pounded his
agree,
fist
you
once
appeal.
again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct alone, as I've outlined already on the record. So the only request that he made
Yeah,
was as it relates to the
That's
bail
it.
jumping counts.
He's
I'm
a
denying those
chronically
requests, whether it be to dismiss one
abusive
count or to dismiss both on
person
double jeopardy, or to just not instruct the jury.
who has always
however
been
way I
able to
interpret it, I
intimidate
deny
other
that. All right,
people
let me go through the
into doing
state's-
what he
Can I
wants.
just add one more?
Sure.
I'm sorry, 154 summary
The
evidence.
judge has the
I believe
full
we had a
power of the
map,
state behind
Actually,
her.
2 maps that summarize we had 3 maps. I think the one was summarized his routes. the
And
path he took,
knowing
and
that
one
she's
summarized
going
the
to
steps
sentence
were struck
him
in the specific
to life
locations,
in prison,
and the other
she
one
knows
summarized
he's
the
not gonna
positions of
show
the
up at
law
her
enforcement officers at
house.
the various intersections and throughout the parade routes.
I'll make a note of that. I don't believe I saw the jury view instruction either. I mean, that was given to them at
Oh,
the time.
here
I don't
comes
know
the
that it
box
needs to be
sport.
reread, but I think we need to consider that as well. And that was my version of 152.
Here,
All right, so let me go
here's
through,
the box
the
sport.
List from the state,
Come on, deputies, don't let him do it.
page 61.
Don't let him do it, deputies.
So I considered the request by the state.
The judge isn't looking at her monitor clearly.
The charging document. I'm going to deny the request to include the specific case numbers. There's evidence, of course, that was received regarding the 2 separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and make a
Like I said,
determination as to the verdict
generally,
forms, though that
this
was
is the
referenced
most
previously. It is
boring
the
part
description
of the
in jury
trial.
instruction that,
His inability
obviously,
to
the third count of
behave,
bail jumping
though,
is incorrect. That needs to be battery, and that change will be made. I'm also
keeps
having
us
them
here.
include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case, I want to be very clear with all of the numbers. So I think I've addressed the first 2 bullet points. As far as the motive instruction as a standalone, I believe that is appropriate, and I'll instruct Madam
It's
Clerk
less
to include
entertaining
that.
for us, though, if he's hiding behind the boxes.
As far as where it goes, I'm going to just, any instructions that we add should just be in the numerical order, unless there's a other request that's made. Then the state also made a request.
I would
as relates to
imagine.
jury
I
instruction
mean,
70,
I'm
which is found on page 65.
I'm sure he'll be able to have a
So as it relates to this,
public
the state is asking
defender
that I
appeal
simply,
for him
um,
if he wants it. I don't know
instruct the
that
jury
they'll
based on
make
the pattern
him.
instruction and not include that second paragraph. I had previously advised the jury with another paragraph.
I've
that I
never
was
done
contemplating
appeals work,
including, even if I took out
period,
that big
so-
paragraph that just said, at times, Mr.
Especially
Brooks
not
has
in
appeared from another
Wisconsin.
courtroom. This must not influence your verdict in any manner. What's the state's position on including that, but taking out the paragraph you request to be taken out?
It's fine.
Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiff to move the boxes away from his face.
Yeah,
To be able to see them. He can
that
get them on the
poor
table, but they need to be
court
moved off to the
clerk.
side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting there, I'm putting there for reasons.
Mr. Brooks, do you have any position on the verbiage of jury instruction 70 on page 65?
No question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state.
That
I
is
need to
known
highlight
as
that second
being
paragraph. I will take that out, but
non-responsive.
I will include in the paragraph that reads, at times, comma, Mr. Brooks has appeared from another
And being
courtroom,
non-responsive
period,
in this
influence your
case
verdict in any
is
manner.
a tacit agreement with the prosecutors because you give them what they want on the jury instructions. You're not going to get
Inclusion
what you
of
want.
The instructions that were put on the last couple of pages include 325 impeachment of witness. Its prior conviction, the part about juvenile adjudication, should be struck from the heading. And it should read, evidence has been received that one or more witness in this trial has been convicted of a crime. There were 2 witnesses that was applicable to. The remainder will be as is. And that was 1 witness. For the
So I
state, 1 witness for the
wonder,
defense.
it was never answered. I wonder if his
We'll add that
mom
if Mr.
was
Brooks
there
has any
to
position about these
testify
requests, he
today.
should, he is currently muted. He can
And if she
raise his
wasn't,
hand and I'll unmute.
did she
Otherwise,
just
he can
say
pass a note to the bailiff
no
or simply tell the
since she
bailiff
wasn't
and then tell me and I can
subpoenaed?
unmute him. But unless he tells
Did
me that,
he
I'm
not
gonna assume
actually have
he's made a
control
decision
over
not to
her?
provide further comment based upon the last statement he made to me. Then 141, I believe that's appropriate given the evidence that has been received. That's on identification of defendant is an
Because he
issue.
never actually said.
And that I will instruct the jury.
He just
accordingly,
refused to
unless there's a
answer
request
if
from
he
Mr.
had
Brooks to take that
anyone
out.
to testify.
Is there a request from you, sir, to take 141 out? I'll unmute for that purpose. It's found on page 106 because it's at the end of the instructions. This is the instruction on identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case. Do you have any position on that, sir? You are unmuted, so you can simply answer yes or no. No response.
It's possible.
Then,
I'm
172,
curious
certificate
if
of evidence
he
flight
told her to show up
concealment, I
though.
believe is appropriate given the evidence that has been received during this case.
And that's it.
Yes, sir. You have been.
Am I unmuted?
You are.
He's in protective custody now.
Can I say something?
He won't last in general
Depends
population.
on what you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsible to what you guys are doing?
Because you can't just do what you want. This is court.
Mr. Brooks, I'm going to mute you unless you can participate in what we're doing, which is discussing the jury instructions.
I'm gonna tell the jury the truth. That's what I'm gonna do. I'm gonna tell them what hasn't been told to me.
That's terrible.
I haven't been able
Mr. Brooks, I'm going to mute you because we're trying to
That's
discuss the jury
terrible.
instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct Madam Clerk to take out of the heading the word escape. Should just say flight concealment.
That's it.
And then I've reviewed 154.
Unless he can
I
put
believe
on a
that's
show.
appropriate.
I don't think he cares.
I'm gonna pull it up just as a draft. I'm not sure if there's anything that needs.
And
to
if he does his own appeal, it'll be written in crayon. If a lawyer does his appeal, it'll be done straight from the record. He won't even deal
so
with
the pattern instruction
Brooks.
talks about a chart.
And Brooks
Is there
will
any
not be
request from the state as
present
to just keep that, or
if there is oral
modify that in any
argument.
way based
So
on the evidence that was presented. Because you actually submitted maps and things were received. I don't know that summary.
I think that there was a summary of the victims and the associated counts. I believe that that was exhibit 141.
But that was received, wasn't it?
And there were some charts of the extreme dance team, the formation, and dancing grannies.
Do you have the exhibit list, Madam Clerk?
Brooks
What are
doesn't
those
seem
numbers
like
again?
the
I wrote
type
141.
that knows what a thesis is.
We're just looking for the extreme dance and dancing granny charts.
Grannies is 54.
54 would be the dancing grannies.
Okay.
33 is extreme.
And
So
33
even
is
the judge
dancing.
agrees
So
they need a
54,
long
141,
lunch.
and 33.
Yes.
Do you think the use of the word chart is correct, or should that be?
I would say diagram and maps. The court has allowed the use of diagrams and maps to organize the evidence.
The maps were evidence.
And at this point, we're not very far
What this
behind
instruction says is the
live.
court has allowed the use of a chart to organize the evidence and to assist you in understanding it. The chart itself is not evidence. It is a summary of some of the evidence that was presented or presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence.
And we think 154 should not be given
That's what I was wondering.
because
So
they were all admitted.
they were all admitted based upon how they were presented and the
I apologize.
testimony regarding them. Typically, where that comes in is for use in openings and closings solely that are based upon evidence, and we anticipate those things coming in, not when there's been an actual document that's been admitted. So I don't think 154 is needed, and I'll deny that request. What about
He has not.
152 regarding the view?
As I read that, that was given.
I
prior to the
think
meeting,
if
and I
he
think
had
that was appropriately
testified,
given at that time. I don't think it goes into the
all he would have
jurisdiction of the
testified about
instructions.
was
My inclination, but I
his
wanted to
mistaken belief about the
get the
law.
court's position on that. I'll once again unmute Mr. Brooks and just ask him if he has any position regarding any of these last issues that we've discussed with, as it relates to the jury instructions. Anything from you, sir, on the jury instructions?
Oh, yep, stare
He's
at the
not
ceiling.
Responding to the question. I believe that covers all of the issues that were raised by the parties then. You are. I'll give you one final opportunity to tell me if you have any requests as it relates to the jury instructions, sir. I understand, sir. Your objection's noted. Your lack of consent is noted.
Okay, I don't see what's going on in here. So how's decisions being made without we being able to consent to it?
Sir, you forfeited your right to be present in this courtroom by your conduct, and you have not requested to come back.
Actually, you took a break. So let's make sure the record is correct. You took a 10-minute break,
I did.
at which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been forcing me to come over here from the get-go. Why couldn't you force me to come back over here where I'm supposed to be at?
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that.
Always
If there was a time
inappropriate
you wanted to come back
comments.
in, all you needed to do was ask. You've done that previously.
That's what makes it fun.
Yeah, but
And even during this time, though, you've been incredibly disruptive.
I can't say
At one point, you were muted for an extended period of time and you were yelling so loud, sir. We could hear you in this courtroom. I couldn't decipher what you were saying. And I was also made aware that another branch could hear you. So you continued your disruptive behavior.
that's fine because
Probably
I have the first
Protecting his wife.
So if I'm going to be constantly muted, the only way for me to be
Is
heard
my
is to
guess.
raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break and then we'll come back in the afternoon to go over verdict forms.
I answered yes or no. How do you consent to anything without me answering the question?
Are you going to answer the question, sir?
But you can't force me to do it. You can't
She
just say,
can.
"I'm gonna do this because
Sir, but you also can't stall the proceedings by failing to answer.
I didn't try to start the proceedings. You the one that held me.
I never held you.
She has never held you in
All right, I'm gonna mute him
contempt.
once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk, finalizing the order, print them off again. She has been working on the verdict forms, which are of course separate, which need to be approved by this court. And so those will be printed off. A set will be provided to the state. A set will be provided to Mr. Brooks. We'll take I'll do a 90-minute lunch break. So it's 11:27. So we'll come back at 1 o'clock
Oh yeah,
to finalize the verdicts.
he's a
and the jury
tyrant.
instructions.
He
And
thinks
Your
he's
Honor,
in
with regard
control.
to sequestration of the jurors and the alternates and those issues, did you want to address those this afternoon?
Yes.
Okay.
We can do that.
Thank you.
Okay, I can put on the record that I had the civilian jury bailiffs provide the parties. We have a letter regarding sequestration. There's an emergency contact form. So all of the jurors were made aware of that. They know that. Of course, once the case is, all of the instructions are read,
I already have
and
it
the parties
pulled
make
up.
their arguments, and then there's some final instructions at the end, and the case goes to the jury. Obviously, only 12 of the
Legend
15
of
will be
P.
deliberating, but we can make a more full record of that this afternoon.
Thank you.
All right, we are in recess until 1 o'clock. I'm just instructing the parties to stay until the handout of the verdict, and then you can leave.
At least he's accused of it. Remember, he's listed as 5'2", but that was in the old school French measuring system, which put him at 5'7", which was above average for 1800. So Napoleon's made fun of as being short, but he was above average for his time. All right. With that, I'm going to pause that so it doesn't interfere. Find my other. All right. That's true, Kelly. Sovereign citizen BS doesn't get you anywhere. As Robbie Peterson could tell you from his experience with P. Barnes.
To know where your warrant is.
I don't need
It's clearly posted on the entry of the building.
What, clearly posted that I have to forfeit my right to be free
This
from
is the
unreasonable
prelude.
search and seizure?
Coming into this building.
Yeah, every person is. I'm not a person. I'm a man. I'm not subject to your jurisdiction, and the court has already confirmed that. I'm here.
So Barnes is in the sort of turquoise shirt. Robbie Peterson, the sovereign citizen, was ticketed for riding his bike after dark without a headlight. This is him trying to go through security, but the real show happens at the courtroom.
Here for one purpose. All right.
You can submit or you can leave.
Well, I'll allow you to search, but I mean,
That has to go through the x-ray machine if you want to come in this building.
what does?
That folder.
That's fine.
Yes.
I mean,
That's what we're
I'll
trying to
do
get
that,
you to do.
but you will be charged a bill. You will be
That's
served a
fine.
bill.
Send me a bill.
All right. Can I have your name for the record, please?
And when you come through here, you will be patted down.
Will you state your name for the record,
Pete
please?
Barnes.
Pete Barnes, thank you.
Yes.
And you accept full commercial liability?
No, I accept nothing.
All right, well,
If you
I
want to
mean,
come in, you know the ground rules, that's it. Otherwise, you're staying right there.
well, you guys can search it, but you're going to be billed for it.
Yeah. And they're
And
going
you'll
to
be
pay the
searched.
bill.
That's fine. I don't have any weapons.
Okay.
I didn't come here to raise a ruckus, but I did come here to exercise my rights.
The courts can absolutely restrict recording. And this is like 10 years old. When I was in law school, so 2013 in law school, I had to go to courts for my civil procedure class. We couldn't even bring our phones into the courthouse. So yeah, but this is fairly old. This is like 10 years old. So it being filmed on a potato is unsurprising.
And to make sure that the court does not try to impose anything that I don't consent to.
Your camera has to go through the machine
Put the camera through.
I don't think that's going to work.
because everything has to go through the machine, I'm sorry.
All right, well, if it,
Put it in a bucket.
You can put it in a briefcase.
well,
Put it in the bucket. That's good. That's good.
Okay,
Cameras in the courtroom.
this is him being
Excuse
kicked
me?
out of the
There are no cameras in
courtroom.
the courtroom.
yeah, there is.
No, you have to put that away.
No, I don't.
Yes, you do.
Under what authority?
You have to have a court order from a judge before you can have a camera in the courtroom.
Okay, well,
Yes,
I'm gonna
I
capture
did.
No, you can't.
this on video.
You gotta turn it off.
It's for both of our protection.
Well, you have to turn it off.
No, thank you.
Then you have to leave the courtroom.
No, thank you.
So now they're going to clear the courtroom because he's refusing to cooperate.
This is your notice, so you need to keep this.
I mean, if you're not afraid of doing anything wrong, then you shouldn't be afraid of being videotaped, right?
No, it's like you can't have. You have to submit.
Yeah, but that's an administrative order. I'm not subject to that.
It's the
That's
judicial
for
order.
persons.
Yeah,
I'm not a person. And you have no authority to,
are you
know,
here for
tell me.
8 a.m.s or
for what?
what time's your court?
8 o'clock.
Okay,
That's his mom.
that's a friend. Shut the camera off now.
No, thank you. I do not consent to you touching me or seizing my property, so you need to
Shut the
back up.
camera off now.
I'm not doing anything wrong.
Yes, you
I'm
are.
holding you accountable because you're about to overstep your bounds. That's what you're about to do. And
Step
I'm giving
outside.
you, no, thank you.
Step
I will say
outside
right
now.
here, if you have anything to say to me, say it for the
Step
public record.
outside now.
No,
For the
thank you.
You're not
public
gonna disturb the
record.
court.
He says, say it for the public record. The frauditors and sovereign citizens always think, for the record, for the record. The court record is the only record that matters. And yes, if you're not a person, why did you show up in court? Why do you think that you have any rights in court if you are not a person or a corporation? I mean, it's asinine, but we're ramping up into the good part here.
Step outside.
I'm not disturbing the court. You are.
102. He's refusing to leave the courtroom. I walked on.
Okay, so.
Good night.
I'm not like everybody else here. I'm not a person. I'm a man, so I have
Oh,
rights
he's a
that
man.
you cannot violate
He's
without
special.
legal repercussions, lawful repercussions. As has to be treated
102. He's
as if I have
to leave
rights.
the courtroom and refusing to shut the camera off at this time.
You want me to show you the piece of paper where the court agrees that I can capture on video?
Let me just step outside. Looks like he's leaving right now.
Yeah, I'm going with everybody else, so I've got witnesses. Where are we going now? Howdy. Authority that they do not have.
In case they do something.
Yeah, by the way, the guy, no shirt, he's like, yeah, you go, permission coming through, he will tase me if he doesn't report.
Yeah, because I'm posing a threat. Tase me, you're going to get sued. Plus, it's not like I haven't been tased before.
I
First and last name?
I don't have a last name.
Most people have not been tased.
No.
What's your first name?
I don't have a first name either. I've got a name. My name is Robert. You can call me Robert.
Oh,
I'm not a person. See, you deal here with Admiralty Maritime Jurisdiction, which deals with persons,
Nope.
which I am not.
what are you? Are you human?
I'm a man.
You're human?
I'm a man, yes.
Are you a U.S. citizen?
No.
You're not a U.S.
I
citizen.
was not born in Washington, D.C. or any territory of the under federal jurisdiction, so no, I'm not a U.S.
Were
citizen.
you born in the United States of America and any of the
I was
states?
born in America. Yes, I'm a state citizen of one of the several states.
There's more than 7.
One of the several?
Which state?
Idaho?
Idaho. Can I see your Idaho state license?
No, I don't
There's a
have one.
lot
You
of
don't have
crazy
My
in
person
northern
does, but I don't.
Idaho.
And I don't wish to create joinder with you.
All right. And if you want to just.
Can I get your name, please? E. Smith.
The problem with this clip is you can never play sovereign citizen bingo with it because he hits every single thing. So you fill out the bingo card too fast. Because, Admiralty Maritime. There is no, well, there might be a little Admiralty law in Idaho because the Snake River does have a port like right on the Idaho Oregon border, I think. It might be Idaho, Washington. But he talks about I'm not a person. Just every single sovereign citizen trope he pulls out. And he says he's been tased before. I've never been tased. I've never been close to being tased. It's not normal to have been tased. Ugh.
Thank you. Are you a bailiff or are you a prosecutor? Oh, you're probably a bailiff. You got the air thing in, huh?
And there's our hero standing at the door.
I know. It's not big.
Yep.
Come on in, folks. Are you here for 8:30?
Yes.
Okay. I'm not starting up yet, but you can have a seat on the bench here if you're fine. The bill can kind of sneak up and
I'm gonna go in and speak with the prosecutor.
No, you're not.
Excuse me.
Camera.
Excuse me. You're blocking my freedom of movement.
I am.
All right. Well, P. Barnes, you just admitted to me that you're violating my rights.
No, I'm not. You can't come in with the camera.
Well, you're violating my rights. And this is also freedom of the press.
From behind you.
This is also freedom of the press. I mean, I don't know what the hell law book you're reading, man, but it doesn't apply to me.
You leave the camera with your mother outside the courtroom and you can come in.
You are not God. You have no jurisdiction over me.
God's not worried about cameras, sir. I am.
All right. Well, why are you worried about cameras? Because you want to do something
Against the
wrong?
rules.
Because you want to do something wrong? Because if it's against the rules, that means it's because somebody intends on wronging somebody else because they're afraid of being held accountable. P. Barnes.
It's a nice speech, but you're still not coming in.
Well, I mean, I don't have to go in because you can't even issue a warrant for me.
Might as well leave.
Well, no, I'm going to go in there and I'm going to speak with the
You
prosecutor.
can go in there without the camera.
Well, please step aside. I'm going in.
No, you're not going in.
Don't touch me.
You're not going in, sir.
Let the record show that you just battered me.
Step back.
And you're using. Oh, stop, please. I'm not doing anything wrong. Hey, you know what? You guys are really overstepping your bounds right now.
Put the cuffs on him.
Put the cuffs on. What are you arresting me for?
Tased in front of his mom. Oh. And that is why P. Barnes is our Lord and Savior Taser Daddy. And so, following this, Robbie Peterson, the man who was tased, did a news interview, and he said he's just going to keep on soft sitting because he's right, everyone else is wrong. I believe he did plead guilty to riding his bike without a headlamp. The tyranny. The absolute tyranny. And yeah, so northern Idaho and sort of into Montana as well. They are that is where they're trying to burn books, and there are a lot of people who yearn for the days of 1940s Germany, shall we say. So, which is unfortunate because northern Idaho is absolutely beautiful. Absolutely beautiful. Most of Idaho is absolutely beautiful. It's just it's unfortunate. So, I mean, Teresa, that is the all-time classic sovereign citizen video. Although I will see this is another one. There's Moscow, Idaho, and there's another one. Another foreign capital I can't think of. But this is Officer Cochran. Just a very short clip to take us into lunch.
No, I'm not. I'm traveling. I am going to continue to film, and it is not a crime for me to travel without a license.
And proof of insurance, sir.
What you may have.
I'm giving you a lawful order.
What you may have.
Obey it, or I'm going to.
What you may have. What you may have is the opportunity to read. Whoa!
He didn't even glove up.
This is assault. This is assault. You've broken my windows. I do not consent. I do not consent. Oh, this is police brutality.
I'm fixing
Stop.
to face
This
you.
is police brutality.
I'm fixing
I
to
haven't
face
done
you.
anything. Ah! Ah!
I think so. I think that one is a more there is a longer clip. I don't know if he specifically spouts Moorish ideology, but I think he is. But there are other videos of cops pulling the windows down. They glove up first. Lieutenant Cochran barehanded it. So those are the two all-time sovereign citizen videos. And then there's Article 4, Free Inhabitant Girl. I'm not going to subject you guys to that nonsense today because nobody's ears can handle that. So, with that, I'm going to go eat my lunch. Court should be starting in about an hour, but I'm going to come back probably in about 2, just so that we can return on warp speed again. So, exactly. Just because you say laws don't apply to you doesn't mean you won't face consequences. And with that lesson of the day, thanks for joining me this morning. Unfortunately, we didn't get him testifying because that would have been a real mess. I have a feeling we're still in for a lot of nonsense this afternoon. So, hope to see you again. So, enjoy your lunch.